Hey everybody, welcome. This is another Operation Wisedome. It's February the 15th. We do this every Saturday morning at 9 a.m. Pacific Standard Time, 11 Central Standard Time, and we just have a blast. We come in, we get together with like-minded individuals that are hungry to change our nation, that are hungry to empower themselves, that are hungry to connect with people who understand what it is to be free, to be a creation of the creator, to be the top the top the top sovereign citizen within our self-governing republic. And I know you're like, sovereign citizen, I knew it, Cameron. I knew you was a sovereign citizen. Well, I'm gonna claim it because I know that's the top in our self-governing republic. And you can go look at that 1940 joint resolution that was signed for I Am an American Day to confirm. So I just want to say thanks for being here. Everybody, if y'all want to unmute and just say hello to the world and how happy you are to be here before we get into introductions, y'all go ahead and do that real quick, please.
Hey,
Hey,
hello.
Hey,
Love you
hey.
all.
Hello, world.
Howdy, howdy.
Greetings.
Hello.
Nice to see you in
I'm
here,
fired
Kevin.
up for natural
What up,
law.
guys?
It's nice to see you in here, Kevin. So, what I want to do first, and what we always do first, is we'd love to engage with everybody. We want to know who you are. I want to be your friend, so don't hide off in the background with your camera off like a creep. But maybe you are, and if you are, guaranteed you're still gonna have fun with us in here. Okay. So, what I want to do is, if anybody's in here for the first time, which I know I do see some, if you could just come on and introduce yourself, tell us where you're from. Try to make it less than 60 seconds if you can. We're not doing explanations now. At some point, we'll get into explanations as far as maybe your situation and how we can help. We love doing that. Because everybody here, at least, man, well, we started this off in the beginning of December, and there's some heavy hitters here, y'all. Okay, I know Bryce is a heavy hitter. Thomas is a heavy hitter. Troy is I mean, we got them all. Okay, so what I want to do is, again, if you're here for the first time, please come up, get your face on them. Undo the camera and come up and introduce yourself. Tell us where you're from and where you're coming from. Why you're joining.
man, I'm trying to get her back on.
Kevin, you're gonna have to do so.
You talking to me? Yeah, this is my first time here. I'm just trying to figure out if you guys can even hear me or not.
Yes, sir, we can.
Yeah, I'm from Wisconsin, and yeah, first time here, and seems like pretty good outfit here. A lot of people with a lot of knowledge. Well, just trying to, figure this whole Zoom thing out. I just had to download Zoom. It was my first time on Zoom on my computer, and I didn't even know if my audio would work. So here I am.
Here you are. It's working, Papa. You good? So me and Kevin and his father spoke yesterday. And what was very interesting about his situation is that he was literally just asleep at the gas station. He didn't want to drive on the roads drunk. The attendants, I don't even think they tried to wake him up necessarily, but um, he had been there for like 4 hours sleeping, and he gets woken up by the cops, and they take him to jail for DUI.
Yeah.
How is that possible? I don't know, but he's got a serious civil suit, and yeah, we're working with him on the background. But him and his pops have already been working on things, and I think it's just awesome to see that. And y'all tell me if my gain gets too loud here. I don't want my microphone getting too loud, so y'all let me know if it's too loud. But
Sounds pretty good right now.
okay. But yeah, Kevin, welcome. I'm glad to see you here. It's really, our text messages last night just really empowered me, man. And I hope that we continuously empower you. And I know you'll see it from everybody here today, how we are continuously empowering ourselves. All right, who else is here for the first time? Please come up and introduce yourself.
How you guys doing? My name is Joe. Can you hear me all right?
Yes, sir.
All right. Hey, Cam, just want to let you know I appreciate the work you're doing, man. It's awesome. I've been traveling around. I have private tags on my automobiles. I'm trying to convince the rest of my family to follow suit. My wife is a little bit harder to convince. She doesn't want to deal with the hassle. So, you know, I'm hoping here I can kind of gain a better understanding of the court procedures. I've been doing a lot of studying on it.
Okay, now wait. If you wanna understand, you're gonna stand under something.
I want to comprehend. You're right. I
No, I
understand.
know. I'm just playing with you.
No, I got your. Well, you make a good point because when we're talking in plain English, you kind of take that into the court, and you kind of, you can get tripped up by doing that. So, but yeah, I want to comprehend the court procedures to dealing with, correcting my status and dealing with this. So, anyway, I appreciate the work that you guys are doing. You guys are rock stars, and I'm just here to try to absorb as much knowledge as I can.
Well, welcome. Thank you for being here, man. We appreciate you being here. What state did you say you're from again?
So I'm in Virginia.
Virginia. Cool.
Yep.
All right. Way over there. All right now. Who else we got here for the first time? Y'all come up and introduce yourself, please.
What's up, people? John. I'm from California. I've been studying this whole process game for about 2 years now, and I don't know how I got an email from you, but it's just divine timing. I want to learn how to live in my space. I told my wife that when I say the world is mine, that's my space. That world is mine, and I'm taking it back.
Amen, brother. I love that. Boy, you coming in strong. Watch out now. Cali in the building. Yeah, that's how it be. Yeah. So my whole thing with everything that we speak on is based on the aspect that we are creations of the Creator, man. There's nothing above you. If you don't hurt nobody, there is no crime. Just a quick plug, shameless plug, quick shameless plug. So when we get to speaking about who you are, we just got done publishing this book here, which is Self-Governed, Bruh. Okay. Everybody's been pre-ordering it. We're finally getting all of them done. What is this? Wednesday next week is when they should all be done, including stickers. And it's called Self-Governed, Bruh, for a reason.
Where can we get that?
Huh?
Where can we get that?
Oh, let me see. www.tlatoani-machi.com/self-governed, bruh. Boom. So links in the chat right there. And just what's amazing about it is the aspect, though, that when we're going through everything, without corpus delicti, without a corpus, there could be no delicti. But the aspect is, again, no, we are creations of the Creator. The line of authority goes God, man, and then everything that we create up under us. Unless we harm somebody, there can be no crime. But it's just really powerful. This book is so powerful because it takes us all the way through the process of how we are able to enter and understand the deeper principles of law, take ourselves out of the aspect of control, right? That we somehow are under some kind of corporation, and then brings us back into the aspect of empowerment by utilizing faith in your religion, in your beliefs, right? And then putting that actually into practice and place on the deepest of deepest levels, which is injunctions, okay? So when we come into the aspect, again, of all of these people, it's because we're allowing to put ourselves under the jurisdiction of the courts, and we have to stop doing that. We got to stop. We have to stop succumbing to thinking that we even have to go and battle them. Because again, if they're making a claim, they have to prove it. Okay. And we can put certain elements in place to make them prove it without having to even attend. It's like, I'm not going to attend until you prove it yourself because I'm the highest of authority. Right. So who else we got here for the first time? Please come on up and unmute yourself and introduce yourself, please. Come on now. There's a microphone. You just push it and it unmutes you. You got to find it, though. It's a microphone.
I'll pop in and say what's up. I haven't been on the live show very often, but or maybe not at all. It's a little early for me. I'm in Hawaii time, but really appreciate what you're doing, Cam, and everyone else. And I kind of silently just peruse the Discord and learn what I can, and am just preparing for any tyranny. And yeah, thanks for holding this.
Thanks, brother. Thanks for being here. We really appreciate it. Because if you're here and learning, we're all learning. It's like, again, this is a mastermind. Like a lot of people think that mastermind is one person that knows it all, but it's not. It's a collective group of individuals. Who else we got here? Y'all unmute.
I'm here.
Snow Ghost, James Stevens. I'm from Michigan, Manistee, Upper Peninsula.
Okay.
I've been in the group for a while. I haven't been on the live show. I haven't been able to catch it again. It's 12:30 in the afternoon here for me, so I'm 3 hours ahead of you.
Yeah.
But yeah, Cam, I found your channel. Actually, I was following Brandon, and I was just looking for live facts, and I just so happened to run across your videos, and I was showing my buddy who was also interested in following the Constitution and getting the word out there, and I was just like, hey, Cameron's getting this out live and showing everybody. This is exactly what people need to see.
Yeah.
So yeah, definitely appreciate what you're doing here for us.
Thanks, bro. It's not just me though. It's all these people that you see, man. That's
Yeah,
here too as
exactly.
well.
Everybody's been a big help.
Yeah, everybody's. I mean, because I can come out and put out the information, but everybody's actually now going out and doing the action, right? Like David's coming out, and David Slow over in Michigan, right up there with you. He's got a big civil suit coming, bro. We got lots of action all over the place right now. It's really wild, man. Thomas, he's got a civil suit coming up pretty soon that he's about to file. Another one. I mean, we're getting action all over the place. So it's not just me. It's everybody. And it's pretty amazing to see. All right, who else we got here? Come on up and introduce.
Hey, this is Andrew. I just finally figured out how to unmute myself. I'm from Dallas. I've been kind of studying this stuff off and on, well, as much as I can. This is the only kind of thing I even look at now.
What part of Dallas you out of?
I'm in Saxe.
Oh, Saxe. Okay. Yeah, I'm from Dallas.
Yeah, I know. I saw that recently just the other day. I wanted to say, hey, Dallas checking in.
Yeah.
That's awesome.
Yeah.
Yeah. So I'm just trying to learn it. I have I got a DWI the other day, and I know what's really happening, but I don't know how to do it right. And I got a lawyer, and I know.
Why you get a lawyer? Oh man, how much? You better get your money back before he starts chopping it away. Get your money back.
Yeah.
Now, let me ask you this: did you do the test?
I refused the field sobriety and I refused the blood test, and
they get a warrant.
They went and got a warrant and took me to the hospital.
And did you have any beverage in the car?
Not that they said.
Well, okay, so they didn't find one?
No, but I fucking told them I had two, like an idiot.
No, you should have said that.
Hey, why you talk, bro?
Because I don't know. It was just.
It's all right. It don't matter anyways because you didn't hurt nobody. All right, so it don't matter. It really don't matter. Yep. No victim, no crime. Okay.
Well, they said Saxe was the victim. I'm like, how can they be the victim?
But exactly. That's exactly how we do it.
Yeah.
You're exactly right. Where's a sworn affidavit or complaint showing someone has been harmed? If they can't show it, it's null and void, bro, until we knock them out.
Hey,
I agree.
Cam, how can they get a warrant? How can they get a warrant when there's no crime?
Right? I don't even.
That too. We ain't even attacked it from that point before. That's a good one. We need to hit it with that one time then. All right, we're gonna hit Andrew with that bad boy.
Man, was it a signed warrant or just a fake one?
No, was it a valid warrant? Yeah.
Right. Mm-hmm.
Well, they signed it. They took. It says they signed it.
It had the seal on it and everything.
I would have to look back at my shit. I don't even.
Okay.
Know if I would be having it. I mean, I imagine I would have it out of my paperwork. Like I said, I don't fully understand how to work like this.
It's all right. This is what we do. You're not gonna figure it out just right now. You're gonna come in the Discord and you're gonna figure it out with us, and we're gonna help you through it. There's gonna be hypotheticals that are made, and then if you want to file documents, we do that too.
Yeah,
that works, bro.
That's what I'm trying to do.
Yes, sir. No problem. Who else is here? I thought is it K? I saw her. So okay, hey dear.
Hi,
hey.
Hey. So I'm also from Texas. I'm down in San Antonio, and I think I found you through Consumer Wizard, who is just one of a few people that I've been trying to learn from. Meek the Zillionaire, my queen. I love her. And then I saw you were with Brandon soon, but I don't like Brandon too much because he's just too nasty. He's too nasty for a girl. I like what you said about us being divine, or, that God and then man, because I was thinking about this just yesterday. They treat us like a resource, right? And what is refrain, do it again. So we are the refrain of source. We are source, and they treat us like a resource, which there proves our divinity.
Perfectly said. Perfectly said. Yeah, we're divine. Most definitely. There's no 100% about that. And that's crazy that you said that. It's like we're their resource because we are the source.
Yeah.
We have a divine purpose, but they've repurposed us. Oh, you see what I'm saying?
Yeah, we got to defeat all these assumptions and presumptions.
Oh, man, Thomas, give me some of that fruit, bruh.
Yeah. Like,
hey, come and hook your ass up. Nice. I seen that. You think you're just going to sneak away with that? Give me some. All right, go ahead. Sorry, dear.
Yeah, no, you're all right. Yeah, well, I didn't get pulled over. I was the victim of a hit and run, and this is what happened at a QT. And I told QT, hey, man, aren't you going to call the cops or something? Because this dude was just driving like a wild man. They're like, no, but if you want to, you can. And I thought, well, I don't really want to, but I think I'm going to try it. And cop comes up and he sees my expired registration. And where's your insurance? I'm not going to give that to you. What about a driver's license? No, sir, you're not going to get that either. And, he was like, well, I'm going to have to tow your car and this and that. I'm like, no, the fact that it's expired proves to you that I don't want to contract anymore. So that's your proof. Why are you assuming that I want to contract? My expiration is proof that I don't want to. And he was like, oh, yeah, I'm going to have to. And then he just drove away. So I loved that for me. I thought that was really, I was so proud of myself for standing up to him. I was nervous as fuck though.
Yeah.
But yeah, no, I didn't give it. I gave him this little sheet of paper that I copied from Rachel Ruby. Do you guys remember her out in New Zealand? By the way, she's been in solitary confinement for like 5-6 months. But yeah, so I got one of those. I just wrote it down. My name, I do not consent. I revoke any and all deceived consents and do not contract. And then on the back, I wrote legal entrapment is unlawful and a crime. And he just looked at it and he was like, okay.
Nice. That's awesome.
So yeah. I also was able to get a hotel room with that and cash. So those are 2 wins for me. But
that's cool.
I don't know what I'm going to do because my problem is like paperwork.
Okay.
Paperwork. Since the time I was a little kid, I haven't wanted to do homework. And now I'm finding myself like, I have to do paperwork. And I'm just lost on it. It's like every step. Oh, well, to get a P.O. box, they needed all these affidavits. I wrote all these affidavits. They're like, no, you're going to need a lease and a driver's license. Like, damn, I don't have either of those. So, okay, I can get the lease probably. I can write an affidavit. But my driver's license, do I give him my old driver's license? Because I do still have it. I just don't want to give it to him. It's got a prestige address on it. But it's not where I live. So it's not a good driver's license anyway. My birth certificate, I was born on a military installation overseas. So they don't want to give that up. So I'm like, well, I have my Bible. And that's kind of it. My Bible and my name, my skin. I think they should give up their rights to me instead of the other way around, me having to do paperwork. Like, why can't you guys just leave me alone?
Right. I feel you on that. All right. Well, it's nice to have you coming from Texas. If you need to work on some paperwork, we're all working on paperwork in the Discord. There's a bunch. It's a lot, but we definitely helping. Like, we definitely build skeleton. And actually, at some point, I think after Zeke, I may go through something today in relation to jurisdiction. I want to allow Zeke to get the floor, but what I wanted to touch base on was jurisdiction and just some approaches and things that me and Luis this week have been developing, and just bring that to the forefront to kind of see some of, Luis took about 2.5 days on a case law search specifically just for case law, and put it together in such a robust way that I was just like, oh my gosh, and literally every quote just defeats any and everything that can possibly be brought forth in relation to jurisdiction. And I just think it's really important. And we shared that in the Discord, but I might go over that today as well. Who else do we have here for the first time? I think we had Jack Cordell here for the first time.
Yeah, what's up?
Hey, how you doing, brother? No, I've seen you before, Jack.
Oh,
Haven't I?
yeah.
Have you been here before? Have you been in here before?
I might have been.
I
Might
think
have
so.
been.
Your face looks familiar.
Yeah, I sent you that Dukes of Hazzard clip though.
Nice, bro. Everybody was
Cool.
digging
No,
that in the Discord, bro. Yeah, everybody was digging that in the Discord, bro.
Okay.
How did you end up finding that?
Oh, I got the whole complete series of a Dukes of Hazzard, and I'm just watching it. I'm like, yo,
You look
because
like one who would have a whole complete Dukes of Hazzard set list. I ain't even gonna lie. I'll come over your house and trip with you on some shrooms too, buddy. Let's do it.
because all the time on every episode, it's the cops. They're always going after the Duke boys for some bullshit reason, and then they're always like, "Wait a second, like you can't do this because and they're always rebutting shit." I'm like, "Yo, this is great for like this movement, ain't
Ooh, you're right, bro. You just sparked a new idea. I just got goosebumps going down my.
Good.
Dude, we're gonna have to work on this together. Then, how about it?
Man,
You
yeah,
want
you
to
got
make we got to make up a clever name with this, and maybe like relate it over to rebut that shit. Because it's like you just said. Yeah, man. Oh man, bro, Jack. Wow. Okay. Get you affiliate link set up, bro. How do we do that?
I have no idea. I tried
Me
one of those
either.
last week, and that I don't know.
I don't either. I'm not that kind of tech guy. I need to get on that type shit. So, okay. Is that everybody for today so far? Is there nobody else here new for the first time in this bad boy? Because this one's been a long introduction, but I do want to know each and every one of you. I truly put my heart and soul into this. My spirit is into this. Yo. So yeah, I just want to know you because again, I am you and we are us and we are all part of the great I am. So with that, I really recognize it and yeah. Okay, we're good? All right. So who I
Cameron,
want
can I say something?
not right now. I'm gonna move into Zeke. We're already 48 minutes in. So
Yeah, I just want
Zeke,
to
if
say
you
something real quick.
okay, well guess you just take over then, man.
I don't want to take over. I just wanted to make a comment. When I was trying to find the link to get to today's video, I noticed that one of your videos already has reached over 3.3 million people. I just want to let everybody know that.
Yes, sir. Yes, sir. We've gone viral, and again, you got to recognize that it's God. This is God. This isn't me. This isn't you. This is God bringing this forth at this time. Man, it's getting crazy because I don't even want to go into it. I'm not supposed to go into it right now. Okay, Zeke, it's your time. Where you at, Papa Bear?
Okay, so
Do I need to give you screen sharing capabilities here, or do you have them?
no, I don't need screen sharing capabilities because when I first met Cam, I got
Your
an email
camera's not
from
on
her.
though.
My camera's not on. I think I was going to let's see if I can get it on because it wasn't working.
Oh.
Okay, so they got it on, but I can't get it to work. However, I was going to come in and say, okay, so I'll put my camera on if everyone else puts their camera on. Okay, because if I like to see who I'm talking to, when I give a seminar, I meet the people at the door, I look them in the eye, I talk to them, and I figure out who they are and what they are. And so I would like to turn my camera on, but now this is my biggest problem is this technology stuff, which a lot of people in here have too, that how to do it. And so that is what this is all about is just a short, it's not what you're saying necessarily to the cop or anything or the judge, it's how you say it. Because then they realize that you know your stuff. The minute they know you know your stuff, they know, and so then they go find another victim. Okay, so back to I got this text and they said go listen to this guy, and I said okay, and I go to the channel and I go, this guy is me, he's exactly me, and then he says his handle is I am you, and I'm going okay, so and I'm going back more than 40 years when I started this, and I had the vision, and I took my plates off. We were probably the first ones in California, and we have a right to travel, and we're not driving in a commercial venue. And so, but we hadn't developed all those ideas, but we knew we had the right. So when we took it off, and then when we talked to the cops, they were like this other, like this sheriff we saw. Well, how do you? Well, we never heard this before. What we never. Okay, well, after 2.5 hours on the side of the road, they go, okay, well, go talk to I'll give you a ticket. You go talk to the judge, because that's what we don't handle it. Oh, okay. Well, we'll go talk to the judge. We'll tell the judge we got rights, we got this, we got the Constitution. And the judge says, well, I'm not going to hear that, and proceeds. So now it's like, okay, well, we go over and talk to the public defender, and, what's going on. And then the public defender says, we explain a little bit to him, and he says, well, you know more about this than we do. And I'm like, oh, we're in big trouble. Our whole country's in big trouble, because how do I know more than a lawyer? And I just started reading this stuff. So now we got to become lawyers. Okay, well, then you go to court, we get hammered. And, we stood up to them, but we got hammered. And we made a slight mistake in taking all our driver's license and getting rid of them, taking all the registration on our cars and getting rid of them. So then when they attacked us, we were under attack, and then we couldn't even do anything, couldn't go anywhere, and we had to get people to take us places. And it's because we're law-abiding citizens, and if they say you can't this or that, so we had to fight it like from the bottom up, and we didn't know anything, and we didn't have anybody to talk to. And that's the biggest thing I see here with Cam. Now we have a place to go, and we've done a lot of things, and we didn't have videos, and we didn't have computers back in that day. So it's all developed, and the whole time I've been watching what happened, and learning the language, which is the court procedures and stuff, which that lady said she's working on. So we're all working on these things, all at a level. And so I'm an analyst. See, I'm not a lawyer. I'm not a videographer. I don't know much about this technology. I didn't even want to learn how to do emails. And then when emails came in, I'm going, oh, shoot, but email really is like driving a car. If I want to go somewhere, I got to be able to learn how to do an email. So I got down and I studied and figured out enough to do an email. So, and that is, you have to go through a process in order to gain this knowledge. And that's what the court is, you gain the knowledge. And so then it comes down to the approach. How are we going to approach this situation? The cop comes to talk to us, we can just spout out we're sovereign, or we can actually show him that we're sovereign. Because when we tell him we're sovereign, he's getting like, okay, well, let's see if you are, and then all of a sudden we're not. Okay, so we're not there because we said we're there. We're there because we showed we're there. So it's down to a word game. It's all a word game, see? And so if you understand the words and what they mean, because they mean one thing to the cop and they mean one thing to us. So yeah, I'm traveling. I'm in a commercial type situation, or not in a commercial type situation. Well, how do we know? How do we know? See, we make a decision in that we know a fact. That doesn't mean that everyone knows that fact, and that's how the courts operate. But it's both ways. So we have to have a perspective. Okay, we start with a perspective. Now, what's our perspective? Our perspective, Cam says, well, it's we're children of God, and we're free, totally. Okay, so that's our perspective. What's their perspective? Well, we got to regulate everybody because we want to control. But that's the we is the everybody. Now, what's the cop individual perspective? Well, I got to make money, and I got to do my job. So I do what I'm told. I don't think about what's really going on. And you saw that in the video. The first cop, he's doing his job. The second cop, he's like, well, okay, what's going on? Wow, I didn't know that. You know, I knew that, but I don't know that. Well, wait a minute. We control, but you're saying we don't control. That we got to, what? Okay, so now what are we going to do? How are we going to convince the guy? See, we could turn it off and say, you know, I'm not going to talk, and that's fine too. And then we're dealing. Then that means, okay, we'll go explain it to the judge. But we can educate all these guys, and in the end, they're going to write a ticket or not. That's how it works, you know. And a lot of times we can convince them not to write a ticket. But how did we convince them? You know, I had a friend who he learned all this stuff, but he would never use it because he wasn't that kind of guy. Anytime he got stopped, first thing is he's talking to the cop. Then all of a sudden they were both in the war, and now we're talking about what happened. And all of a sudden they're great buddies. And then the cop says, "Oh, hey, dude, you know, you were speeding along the way, so just slow down. So get out of here." And he would never get a ticket because he could talk to the cops. You know, it's a salesman. I mean, and it wasn't anything about law at all. See, so how are we? It's all putting together our personalities and how we relate to the cop, because the cop is an individual and he's a cop, and we're individuals and we're patriots. Okay, so what does sovereign mean? See, they're looking at it as a sovereign citizen. Well, I go to the dictionary and I go, oh, sovereignty is the paramount control of the Constitution and the frame of government. Oh, okay. So, am I sovereign? Well, not yet. I got to learn how to work the Constitution. Okay, and that is done through the court process. Okay, well, what's a court? Well, a court is really just a place where issues are resolved. Okay, so we have to understand when we go to court, we're not fighting. We're resolving an issue. And the judge, he's not the cop. And so our perspective at first is like, oh, it's the government against us. But wait a minute, we're the government. Okay, well, we're part of we're part of the government. They're part of the government. What part of the government are we? And so that to understand that, we have to know what the government is. Okay, and what's the government? The government is the Constitution. Constitution is the government. So when we understand the frame of government and how it works, then now we can exercise sovereignty. We're not sovereign, we exercise sovereignty. So this is what I do. I analyze, we break it down, and we have to have a perspective. Now, our perspective can either be general, like overall broad perspective, but then when a case comes to us, then we have to be specific and very particular about our case, because every single case is different, but generally they're all the same. So our approach is, okay, this is the same. Okay, I got a ticket. Okay, so we know how to fight tickets generally, and then we look at our specific ticket and how we can fight our specific ticket, and also look at it generally, because they're all the same. They're all the same, but they're all different. So when we go to court, really they're all the same generally. And we start with understanding what court we're in, because there's different courts, and that leads us to what jurisdiction we're in. So Cam was going to tell us about jurisdiction. Well, when he talks to jurisdiction again, I'm going to hear it and I'm going to know specifically what he's talking about. But a lot of people in here don't really understand what jurisdiction means. They have a general idea, but there's a lot of specific jurisdictions. So we have to focus down. So when we're shooting at a target, we can take the shotgun approach, okay, and that's shooting, and then a lot of pellets go out. So some of them don't even hit the target. Okay, well, we don't, okay, we show you didn't hit the target. Okay, well, let's focus on the ones that did, because some of them did. Well, the target, you hit the target, but did you hit the bullseye? Okay, well, then some of them hit the bullseye. Well, we got to find out which one of those hit the bullseye. Because when you shoot a shotgun, yeah, something hit the bullseye. And I'm kind of a perfectionist. So I want to hit the middle of the bullseye. If you hit the bullseye, you're good to go. But I'm going to hit the middle of the bullseye. And some of those did in a shotgun, but I'm going to take my rifle or my pistol and my bullet is going to hit the bullseye and I'm going to hit in the middle of the bullseye. So sometimes I get too technical and too perfectionist in my shot. So, hey, because if you hit the bullseye, then you're gonna get out of this predicament you have because you hit the bullseye. Now, the cops and the judges, they're not anywhere near as particular as I am, and they're always taking the shotgun approach, and they don't really know. We got to remember that we think that they understand all this stuff we're saying specifically and driving trial. They don't have a clue, really, because they do their job. That's what they do their job. Then when they're done with their job, they go to the bar and they drink. And some of them, and these judges, why do they drink? Because they really are conflicted, because they know what's going on and it's eating them up inside, but they're going to do their job and do the world order's command to control people, and they don't really like it, but they got to make their money, so they just do their job as best they can to get through and hammer the people, and then they go drink. And then they wake up the next morning and they don't feel good and they're all groggy and they're not sharp. So, so when we know their job and what their process is, because they do it the same thing, then you can go in and just boom, 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 pick them apart, just like you can pick these cops apart. But that's why they come in with the violence at the first. They're the ones that are causing the problem. So it's the approach again. So we don't want to trigger them, even if we're right. See, this is the problem. We have rights, but that doesn't mean we have to exercise them all the time. You have a right to cross the crosswalk, and they have to, and you have that right. But if they're going 90 and that traffic's coming, you want to exercise that right? Boom. Yeah. Okay. You were right. You're dead right. And that's the same with the identification. Okay. You can identify. You don't have to identify yourself. But if you just give them your name right there, that eases them, okay? Because what's their perspective? They're like, oh, I gotta have it. The law requires it. Well, they're wrong. But now, do you want to argue that issue right there now? You got to pick and choose your battles, as they say. So what are we going to do? How's our approach? So this is what I've been running, figuring out for 40 years or so. And so each person has their own personality. How do you want to do it? But in order to do it, we got to know what their process is, how they're thinking, and then this individual guy, because that first guy on that video, yeah, he didn't really want to get involved, but the sheriff, like, he's interested. He wants to learn. He wants to know what's going on. That guy's on our side, so we don't want to, alienate him. So this is what the perspective is. Okay, so that's how I look at things. I analyze things. So now we're going to go into an argument, because there's an argument here or an issue that arises. Now, when you have a child and they say something and you get in an argument with a child, well, you don't discuss it with them. You know, you do what I say. Okay, we didn't like that, do what I say, but the parent tells them, do what I say, do what I say. Okay, so that's it. Now if you have a little argument with your spouse, and you say, okay, well, let's discuss this after dinner. Okay, so you're setting a time and a place. Let's have our court settle our issues. We're going to do it in the manner, and let's do it after dinner, and we'll talk about it and we'll discuss it. Now, when you have a civil action, okay, you have a court case against another person, and you're going to go to court because that's where court is. You go and you settle it. Now, remember, court can be, you're in court as soon as you got an issue talking to a guy, out anywhere. It's just an informal court. So you got to still have your approach and how you're going to settle it. You let them talk. You be quiet. Then you get to talk. So everything is balanced in court. There's no one starts with an advantage, and we have to realize that because we have to take over the court in a sense to make sure that it's balanced. Okay, that the due process and the court is proceeding in a proper way. And remember, when the judge gets in there and he's going, we got to start in a proper way. That means let me get this through. I'm going to do this. We already know. Okay, let him talk. We can't come in there. Hey, wait a minute, I got rights. Get rid of this. Okay, we're not there. We can't. We're too fast on the draw. We're going to get rid of it, but we have to have patience. Slow down. Let him do his things. And no, we're not in his jurisdiction. Okay, but guess what? We are in his jurisdiction, but he's in our jurisdiction. So he's running the court, but we're going to run the court. And here's the key on the cop. We're in court, but he's going to run the court. But what we got to realize is they get to go first. They get to go first because they're approaching, and now we can't say anything because we don't know what their position is. Because we do, but we don't. Because he's walking up to our car, and then he's gonna say, in the general sense, okay, all I want to do is write you a ticket and get on my way and let you get on your way. That's all I want to do. Okay, so we know he's gonna do that. So what do we want to do? Do we want to educate him? Do we want to not get a ticket? Because and so then we work it from there, but we always have to, like the guy said, well, we're not there yet. We're not there yet. I'm still introducing, you're introducing, and then when we hit a place of contention or where we don't agree, then we can agree to disagree. And what are you going to do now? We agree or disagree, but what are you going to do? Okay, so are you going to be the one to violate the law by arresting me or pulling me out of the car? Because I know that's a violation of my right. And I just told you, and you do know already, that that's a violation of my right. So now it's a bluff. So we come to these bluffs, see, and when we understand how we're doing it, and that's in the civil court, we go in and we're suing somebody over, and a civil court is usually over a breach of contract. But we have to also remember that the civil court is not the same as the criminal court, where the criminal court involves government. See, it's not a sovereign against a sovereign; it's a government against us, and the government is the sovereign. Okay, because it's the Constitution. So the judge isn't the sovereign, the cop isn't the sovereign, but the government's the sovereign in this context. But then on the flip side, each one of us is a sovereign. So then the cop is a sovereign as a man. Okay, but when he's doing his job, he's acting for the government. And same with the judge. They're acting. Okay, so it's all a big show. Everything's a show. This is drama. And we're acting. But when we're acting, it's not a show. It's the real deal. But when they're acting, is that, and so when we're in court, we're not against the judge, we're against who he's representing. And that's the criminal. So that's the difference between civil and criminal. And so really when we're going up against the criminal and they're coming at us, but we have a problem that we have to solve to deal with them. And so they're dealing with us in a court civil complaint arena. But the real way that we want to deal with them is what's called a grievance. See, we want to go and we have to redress a grievance that we have for them. So, and to redress that grievance, we can't do that in their court. And that's what we're always trying to do, is redress the grievance and telling them we got rights and this and that. Now, they'll hear it if we've presented properly, but generally, we have to go take them to court. Okay? And that's what, when I realized that and I understood it, see, then I knew I got it. And then I look and I see Cam and I say, he sells me, he's got it. And I go, okay, you got it. I got it. What do you think you got it? He says, it's the injunction. And I go, yeah, you got it exactly right. However, the injunction is for the civil and it's against other individuals. But yet, when you look at the writ of mandamus, that's the redress of grievance, and that's how you present your injunction to the government. So when he sees that the writ of mandamus, it's like the injunction, they're the same, but it's when you present it to the government, it's called a writ of mandamus, whereas in a civil, it's civil court, it's an injunction. Okay, so now that we should see that we got the answer, the concept of the answer, then it's how do you specifically put it on paper and address the court that you're in, and it's our court because we're there to redress a grievance because we have that right under the First Amendment, because we're everything. Our code section is the Bill of Rights, which the 10th Amendment, 9th and 10th Amendments show that, okay, the Bill of Rights, so you have all these rights, but there's a whole bunch more rights that you have that aren't written down. And those are all the rights under God. And that's the general shot, but we got to go pick them out and specifically bring them to our redress. And then when we redress our grievance right there in front of them, and then they have to redress and deal with it. And when they redress it, it's back to, well, is it my right or not? And we have all the rights. And then who are you, Judge? Who are you now? Are you gonna take issue with my rights or not? And then they fold because they can't, because that's not the jurisdiction that we're in. And they realize it. And when we make them realize it, they fold. And so when we get stopped by a cop, okay, once he realizes that we know what we're talking about, okay, he doesn't know what we're talking about, but he sees he's there to make a business decision. So he says, look, oh, this is going to be take up all my time. This is going to take up this. I'm not going to be able to do it, make money. And so I'm just going to let it go. And that's the same with the judge, because they're never going to let up on the secret. They're never going to say, yes, you have the right to travel because you're non-commercial or because of this or because of that. they're going to want to get rid of you on a technicality all the time. And so when we didn't want to get rid of it on a technicality, we got hammered. But the technicalities come up, they give them to you when they see you're going to be a waste of time here, and I'm not going to be able to make money. So that's why it ends up, I'm sitting in court, and the cop the judge is telling the cop, don't bring this guy into my court again. Okay, he's not saying that don't bring him in because he's right and because he's going to win. He's just we're here to make money, and he's getting in the way. So you can do that and get in there by just arguing and bringing it up and causing a problem and over litigating them. But they beat us at first because they come in, you make you appear. Then they ask you how you play, and then they make you appear again. Why don't we just settle all this stuff right in the beginning? Well, the reason why is because you didn't settle it all right in the beginning. We didn't do it. So we can settle it all in the beginning because we know what is going on, and we're not taking a shotgun approach. We're specifically dealing with the situation right now, and we're putting a stop to it. Okay, procedurally. So we're not even ever going to talk about whether you have a right or you don't have a right, or is because is he violating your right or not? Because that's the only issue really. And so drop it, Judge. And if you drop it, then I can go to another court and sue you and attack you, because the way these courts are set up in the first instance, we don't have a defense. There is no defense because there is no defense. Okay, because you come in and you didn't have a driver's license. How do you plead? No contest. I can't contest that fact that I didn't have a license because I didn't have a license. So why are we here? What's the issue? He said I didn't have a license. I didn't have a license, as a matter of fact. So why are we going to court? So they stuck us in the position, hey, yeah, we say you didn't have a license, and you said you did. So let's go to court and have a trial and issue, and they'll prove that you didn't have a license. Well, duh. I didn't have a license because I don't have one, and I don't have to have one. Are we talking about whether I have to have a license or not, or whether I did have a license or not? And so that concept came up. The first thing is, when my license went out, I'm like, oh shoot, I don't have a driver's license. I don't know how to drive. I don't know how to use the gear shift. I don't know how to steer the car. Really? Because isn't that what a license does? It shows that you can do it or not. Okay, so anyway, that's the whole process. That's the way I operate. And so when I'm going to talk to people, they're at different places in their understanding. So if you have this information now, you have to have enough information to create a question. So now if you have a question, then I can address that question. And I can't give a seminar and tell you stuff and teach you something, because whatever I teach, you're only going to learn what you are seeking. What's your question that specifically needs to be answered? Because everybody in here is at level 1 and to level 10. And so I don't know what you know and what you think and where you understand certain words and misunderstand certain words, because this is a word game, and it's a game. Whether it can be a game that hurts and it's a serious game, but it's still a game, and you make moves. And the other point is you have to make your move, because if you don't object or to what they're doing and saying, then they're assuming that you agree because you remain silent. So we got to be careful about when to remain silent, because we have the right to remain silent. And that if you know you have a right to remain silent, then there's really no requirement on their part to tell you your rights. See, that whole Miranda thing came about in '66. Some lawyer happened to be from Nevada County where we did all our stuff. He just wrote up this, recommendation that they read the people their rights. And then after 20 years, that when they came to the Supreme Court about, did they read them their rights? Do they have to? The court said, well, really, they don't have to read you your rights because that's kind of ridiculous in a lot of ways because they should know their rights. But they said, well, it's become custom and usage. So they actually said, yeah, we're going to have them required to read the rights. And so that was just another requirement for them on their side. But they're not required to tell us anything, and we're not required to tell them anything because we're all free and we have the right to remain silent. And that means that just because you're being quiet, they can't proceed against you. However, if you remain silent and they proceed against you, well, they can't do that. They can't do that. But they did. Okay, then that's where we're at. They can't do that, but they did. So deal with it. And the way you deal with it, you have to deal with that. So we have to understand these guys are doing stuff that they can't do. How are you going to solve that issue? Are you going to have a gunfight on the side of the road with these guys? Or do we set up a process where we can solve the issue in a place called a court? Okay, and we know now they're taking us to their court. Okay, now you're going to take me to your big brother. Okay, fine. Well, I'll still come to your court, and then when I get there, then I'm going to get out of it. I'm not going to fight with you. I'm not going to fight with your big brother, because actually, when you look at that ticket as an invitation to the court, it's not a proper invitation. They never really said what you think they said. So when you go to the court and you tell the judge, let's look at the invitation because it's an insufficient invitation, so dismiss the invitation and I can leave because it's the wrong court. I don't belong here to defend, and I don't belong here to prosecute. See, so you can't cross complaint in their court because it's the wrong court. And the guy that's the judge isn't the court that we think it is. And to stay out of it, it's all about the invitation. Their paperwork is always insufficient, but it's presumed to be sufficient. Okay, and that's why we have to point out the insufficiencies, which a lot of people don't think is fair, but that's just the way it is. And when we do point out the insufficiencies, then they get rid of it. Because, oh yeah, that is insufficient. They'll agree on that because that's the judge's job. He decides matters of law, not facts. Okay, the facts are not at issue. Yeah, I didn't have a license. So why are we here? You said he didn't have a license. Did they really say that? So did they really say that we didn't have a license? Did they really say that we violated some law? Okay, not really. When you really break down their invitation, it's always insufficient. So when we find the insufficiencies of it, then we go there to get out. And so once we learn that, how to get out, then we got to learn how to go prosecute. Okay. And we started prosecuting with complaints, but now we know, no, we want to prosecute with a redress of grievance. And that's a whole nother jurisdiction and a whole nother process that's been set up. And these writs, I'll just go into a little bit and then I'll be done. The writs, they came out of England, okay, and they're called extraordinary writs, or they're called prerogative writs. And they developed over there because they're extraordinary, because they're the king's prerogative writs. So the king, when he was running the show, and he had a sheriff to enforce his laws and rules. So if the king came out one day and said, okay, I'm going to make an edict, and I'm going to say that no one gets ice cream on Tuesday. Okay, that's the law, that's the statute, that's I've determined it because the king was the legislative, the executive, and judicial at the same time. So he says, okay, no one gets ice cream on Tuesday, and he said that. And then he looks over at the sheriff, okay, and the sheriff is going to enforce this. And he says to himself, oh, shit. Now, I don't want the sheriff to think that I, the king, cannot have ice cream on Tuesday. It's just all of these people, the subjects out here that can't have ice cream on Tuesday. So is he going to mistake and think that he's going to enforce this law on me, the king? No, no, no. So I have these writs, the king's prerogative writs, that I can now redress my grievance to the sheriff to say, no, that doesn't apply to me. That doesn't apply to me because I'm in a different situation than all these other subjects. So that's where these writs came out of, and they're of the common law. And the law schools today don't teach common law. They say it's been supplanted. You can look up that word, supplanted. Hadn't been gotten rid of, but it's been supplanted. And now that's the remedy that we can each use so that we can exercise our rights of sovereignty, the king, based on just the fact or the thing that when George Washington was leading our country, and the people wanted to make him king, and he said, no, we've set up a constitution to make all of you kings and queens of your own property. So there's my presentation, Kim.
Question.
We are all kings without servants.
So if anybody, thanks Zeke, that was great. If anybody has any conversations or questions they would like to ask, just to add on to that, please do so. I need to take a couple of minutes here, so please ask some questions.
Can you hear me? Zeke?
Hello.
Yeah, my question is simple. It's so you're saying that if you get into the as you get into the court, basically they're agreeing with your adversary on your way in, because there's always going to be second jurisdiction which you're going to seek the redress. Does that mean, since it's your right to stay silent, you just simply stay silent almost the whole way through? Except I'm just as one strategy to test to see if it works. You just don't say shit ever, basically, until they drag it out of you and you get a name, and then you don't agree, you reserve your rights. You don't agree, you reserve your rights. They punish you, and then you get injunctive relief somehow to go to their other court to stop them from punishing you any further, because now they gave you the goods. Did that make sense?
Well, no, yes and no. Okay, so here's the point. Now, we want to agree with our adversary. Okay, so to agree with our adversary before we get to court means that we have to go talk to the DA. So we talk to the DA before court, and we tell him our argument, and we discuss it with him, and then he says, oh, okay, then I'm not gonna prosecute you, so you don't have to go to court. But the way the process works generally is they make you go to the arraignment, and at the arraignment you tell the judge, I'm not ready to proceed because I haven't talked to the adversary. I haven't talked to the DA. I need to talk to him. Now, if you talk to him before you go to court, then he may drop it and then you won't have to show up. But you got to agree with your adversary, and your adversary is not the court. Your adversary is the DA. It's the other side. And you need to go talk to him. And if you don't, then when you get into court, the first thing he's going to say, the judge is going to say, here's the complaint against you. And you say, well, I haven't looked at it yet, so I can't enter a plea yet. So I need to do discovery, and the discovery is you talking to the DA outside the court. It's not a court thing. So that's how you solve that issue before you get there. So you have to agree with your adversary, and the court is not your adversary.
So then at the very end, last thing to tie it up is deal with it so first do the thing with the prosecutor. So we got to lean into this prosecution thing. Because I mean, my first time in, it was like, I'm going to fucking tell a judge a bunch of shit and fuck him. And then that toned down the second time, clearly. But the thing is, I should have gone straight to the prosecutor up front and be like, dude, what are we doing? This is what wait, you're not talking to me, Mr. Prosecutor. Are you just avoiding this question, or find out where his head's at? Because I'm telling you, by the way, they're not, some places maybe they do, but around here, they were not simply going to at the DA level.
Okay, well, wait a minute. That what he says is, before you talk to me, I don't know which case you are. So go to the judge first and get established that where there is a court and that you all have a case, and then I'll talk to you. But if he doesn't going to talk to you on the phone, then he has to talk to you through the process called discovery.
All right. I get you. So it's just a new thing to learn, because I've learned the courtroom shuffle-ish. Good. So it's now the DA shuffle. It's just we're learning new songs each time is how I'm looking at it. All right. I yield.
Zeke?
I got a question.
Ralph, let Ralph go first, and then you.
Okay. I've been wanting to do a conditional acceptance to the district attorney and follow up on my administrative process. And when they don't respond to me, then I'm going to request arbitration. What do you think about that?
So what's your question?
Do you think that's a good approach? Because basically, when you do a conditional acceptance with the district attorney to seek discovery and what have you, and you can't come to a resolution, or they just ignore it, well, then before you even get into court, because there's a controversy because they won't respond to you, well, then that's when you can request arbitration and take it out of the jurisdiction of the court altogether.
Okay, so now because I'm not sure what exactly the question is, but let's look at the situation. First of all, when I come into wherever I go, my presumption is I have all the rights. I don't have to declare anything because I'm a sovereign being. I'm a sovereign in that arena. See, because sovereign, I'm not sovereign. Okay, but I can exercise the concept of sovereignty. So I don't need to declare to them anything because I'm already have all the rights. I have that. I've reserved everything. I don't need to tell them I reserved it. They already know I reserved it. So what are we going to do now? I already got all that. That gets in the way. That's me coming in. Wait a minute. I'm 6'4" and I weigh 150 pounds, 80 pounds, 70, whatever. I weigh this, I weigh that. I'm a this, I'm a that, and I this and I that. Well, you know what? Maybe, but you know what? We're going to just take you as you are, whatever you are. So start there. You don't need to, because just because you declared something, it may be true and it may not be true. It doesn't make it true because you said it. What action are you going to take? not make a declaration. Okay, I think Mitch was up, and then
well, that's where the conditional acceptance comes in. I'll conditionally accept your terms, provided that you provide these answers. You know what I
okay.
mean? And when they
So
don't respond to that,
wait a minute. What answers are you looking
it's a
for?
way of doing discovery without asking for discovery.
Okay, but in discovery, what answers are you looking for?
For them to prove that I'm actually in commerce.
Okay, well to prove anything, that is what happens at trial. Okay, a trial. But why do you want them to prove you're in commerce or not? What difference does it matter if you're in commerce or not?
Well, because they charged me with suspicion of DUI when I wasn't drunk.
Oh, well, okay. So let's look at that. Now, when you look at their complaint, did they charge you with DUI? And
yeah, they're charging me with DUI.
Did they charge you properly with DUI? Did they charge you properly? Because whether you were drunk or not doesn't matter. Because they charge people that are DUI that aren't drunk.
Exactly.
And you go to court and you can prove the guy wasn't drunk or was drunk. That's not the issue. The issue is
my problem is the district attorney and them won't give me any information as to what my blood results and all of that were.
Well, you have all that information.
No, I don't. They won't give it to me.
You said you weren't drunk.
I wasn't drunk. I was under the influence, but I wasn't drunk.
Okay, well, you again see that we like you and I could talk about it, and you can know you weren't drunk, and they can think you were drunk, but that's not the issue. The issue is can they take you to a trial?
Yeah.
Okay.
Yeah, exactly. I mean, the sheriff watched me leave the bar and pizza joint. I was there for 6 hours, but I maintain 1 drink per hour. I'm 6'2", 260 pounds.
Okay, well,
I wasn't impaired at all.
Okay, you're trying to argue the facts, and those aren't the facts that I argue. I wouldn't get there, so I wouldn't take that approach. Let's ask Jack what he wants to know.
Yeah.
Oh, shoot, I almost forgot. So when you were saying about the going to the district attorney and talking to them first, and if they don't want to talk to you, you use discovery. And what if they don't do anything about discovery either? They don't give you any information about discovery. How would you go about proceeding?
Then that becomes the issue. And if you go look, I don't know what state you're in. There's rules, and all states and all courts actually encourage discovery, and you're in California, the rules of discovery are that you first have to do informal discovery before you do the formal discovery, and they always respond because that's the job, that's their duty, and that's their job as a district attorney. And any lawyer, and every lawyer, there are rules, and the court wants you to do discovery, so they do answer discovery.
Oh, they didn't. I did a formal discovery. I'm like where it's been submitted to the courts and to the prosecutor. And so should I just then do a motion to compel?
Yes.
Okay.
That's the rules. Yes. If they don't answer, which a lot of times they don't, then you do the motion to compel.
Well, I got one small last question is, and I'll talk to you privately if you say yes to this. Do you know a lot about we'll say the life stages of a warrant from it being submitted to it being closed, we'll say? Do you know a lot about that subject with warrants?
Well, it all depends on what you mean by a lot.
Pretty much like how it's closed out. So I guess so. Pretty much, let's make some assumptions here that they did the whole warrant process correctly, okay? But then, and you're in jail now, awaiting your arraignment. But on that day that you got put in jail, they then filed a motion to vacate warrant, vacated for not. So would that be something you know about? And
Well, I do know some stuff about it, and I have to look at it specifically because it's hard for me to understand what you're saying. And
okay, I'll contact you privately later on.
And just to say, I presume that they never did the warrant process properly. If there was no crime.
That would be correct on there, but we'll chat more later.
If there was a crime, then you have to deal with that. Yeah.
Right. We'll let some others talk.
Okay.
Thank you.
You're welcome.
Zeke.
Yes.
Okay. So I basically, that's what I was going through too with the discovery, reaching out to the prosecutor and the front desk telling me that I have to go to court in order for me to get the discovery.
Well, if you look in the rules don't say that. But again, on the other hand, you may have to appear in the court, and then the court then tells the DA that there's a case or whatever, and then you do your discovery. The discovery is if you have a case number, and then you put your discovery together. It's kind of the reverse of a ticket or a complaint. You send it to the DA or the other side, and they have to follow the rules. And in discovery, when you look at discovery, okay, discovery is composed of three things. It's your interrogatories, depositions, and admissions. And there may be another one, but these three or four things are all considered forms of discovery. They come under discovery. So when you send, and they have discovery forms now for interlocutories, and when you fill it out or you make it out, in the beginning you lay out the terms. You say what these words mean. You say what they're required to do. You have to answer this within 20 or 30 days. And you have to answer under penalty of perjury. This is just the discovery process, and it's really like the way a cop writes a ticket. He has to do these things, and he has to give it to you, and you send it to the mail and through the mail, and it's called proof of service. And then you proof of service them, and then So then when they don't answer you, then you do what's called the motion to compel that we talked about. And then you go in there, and the judge makes an order, and he orders and compels them that they have to answer it. And one of the sanctions is if they don't answer it, then the case gets dropped. So if they want to talk, then it gets dropped.
Okay, thank you, Zeke.
Hey, this is Mitch here.
Hey, Mitch.
Hey, let's go back to at the beginning is when you were talking about when an officer gives someone a citation, that citation is an offer to go to court. And you were saying that offer is not the proper way to require us to go to court. Could you explain on that a little bit more and give some examples of what we need to be looking for?
Okay, now it's the proper way, but it's insufficient if it's insufficiently filled out. Say it's a complaint. Now, a complaint is basically the invitation, and the complaint has requirements that it has to have. They call it the four corner rule. Now, if you just look generally at what a complaint is, and they liberally construe these complaints, because in the common law, if you didn't dot an I or cross a T, they threw it out. So we want to be more liberal. So you have to have three things for a complaint. You have to have a claim for relief. You have to have the right to that relief, and you have to have a short, plain statement of the jurisdiction of the court. So all those three things have to be there.
Well, when some people read the complaint in court and they asked them if they understand that, they said, no, they do not understand the complaint. What are they talking about there? Because the court is assuming we're supposed to argue the presumption because we are not in that venue. We're not in that commercial capacity that we're trying to make money.
Wait a minute. We're not there yet. We're not there yet. So he read the complaint, and I have to see the complaint. I have to look at it, because when the judge reads the complaint, he's reading it. He's not looking at it. Okay, see the difference? He's just reading charges, but those charges have to be sufficient and laid out to constitute what we call a cause of action. Okay, so when the judge reads it to me, go, well, okay, judge, I don't know what to plead. I don't know how to plead yet. Let me see the complaint. Okay, now when I see the complaint and I look at it and I go, well, this complaint's insufficient. There's something wrong with it, right? And so I'm not prepared to answer to this. I can't answer or plea, but I can respond to it. And the way I'm going to respond to it in California is by entering a demur. Now, other jurisdictions and the federal, they abolished the demur, and they said, no, you do it by motion to dismiss. So you can, and in California, you can either plea or demur. Okay, so I choose to demur. Now, they also kind of is a little trick, like a trap, because once you've pled, then they don't allow you to demur. But they entered the plea for me, and then I go, well, I'm going to demur. And so if they enter a plea for you, that's not you entering a plea. And I've demurred after I've already pled, or they pled, and the judge allows it, generally. He doesn't just say, oh, too late. Oh, okay. If he says, oh, too late, then I say, okay, well, then I'll put in a motion to dismiss instead, because you can make motions after you pled, but you can't demur. But my motion to dismiss is going to be my demur, just a different name. See, this is how the game is played. So yeah, you can move to dismiss.
Yeah, I'm always looking at the most simplest way to fight these charges without going through a long, lengthy process.
Right, but you don't want to fight the charges first. You want to fight the ticket. You want to fight the complaint, not the charges that are on it. Yeah. So it's in the wrong framework. Yeah. Okay.
And when the complaint is all boxed in, is that taken off the page, Zeke?
What do you mean?
When you get the complaint and it's all in the boxes, are those charges actually on that page that the judge is reading from? Because it's with the four corners rule.
Well, I don't know. I have to look, but the boxes, the boxes are I think I say you're saying, and I would say no, they're not. But he's reading charges, and charges have to be set in a formal jurisdiction, and that's the complaint itself, the jurisdiction, and everything is on the face of the complaint. That means it's on the complaint only. We're only looking at the complaint. We're not looking at any of the facts that we know or don't know. Just the complaint itself.
Demure is an old way of pleading. It's an old-fashioned, old country barrister English way of pleading without granting jurisdiction. In other words, I'll answer out of courtesy, and I'll give you an answer out of courtesy, but at no time am I granting jurisdiction. Now, I put on my briefs. I state my name, I state the defendant in propria persona on a special appearance is distinguished from a general appearance for jurisdictional challenges. Now, I've raised the issue of jurisdictional challenges. I'm putting on the record. It's clearly cognizant. Once jurisdiction is raised, the burden is on the plaintiff to prove jurisdiction pursuant to McNutt versus...
Okay, that's another way of saying it. But remember, with jurisdiction, what jurisdiction are we talking about?
Yeah.
And we know, we have to know any question that we ask, we know the answer to. And the same with the judge, he knows the answers too. So when we discuss stuff, it's all with the judge, it's all about his jurisdiction. Okay, and his jurisdiction is you can call it commercial jurisdiction, okay, and you can call it the administrative jurisdiction. And
let's get into it. If we're gonna get into jurisdiction, let's just break it down.
Let me finish this one. I just gonna say that, and I call it the probable cause jurisdiction. Go ahead, Cam.
All right. So I was going to get into this little comprehensive legal analysis of jurisdiction, and it's a constitutional and procedural framework, right? And actually, if y'all want to view this or grab this, what I'll do is give this for everybody. Give me 1 second. Copy, close. Where's the chat, y'all? Let me see. How do I do this? Chat. And here you go. So if y'all want to get into this, you can get to it right there in the chat. That's the link. So everybody can get that provided to you for free to kind of go into this on your own leisure or time. So this is an introduction. So jurisdiction is derived from Latin, which is juris, okay? That means law. And dicio or dictio, which is speaking, okay? So law, speaking, jurisdiction. Got it? Is the lawful authority of a court or governmental body to adjudicate disputes, enforce laws, and bind individuals to its decisions. Jurisdiction is essential component of legal legitimacy. Essential. Gotta have it. A must. When properly exercised, it renders proceedings void ab initio. What is void ab initio? What is void ab initio? Come on now. Y'all gonna talk with me today. Y'all ain't gonna make me speak by myself. Okay, thank you. Thank you.
From the beginning to the end.
Let's fucking go. All right. Speak
Void
it.
ab initio, nunc pro tunc.
You hear these motherfuckers? They know what they talking about around this bitch. All right. My bad. I called y'all motherfuckers. Excuse me. But you know what I'm meaning. Y'all know what y'all talking about. Jurisdiction is firmly rooted in constitutional principles and procedural doctrines. The U.S. Constitution, we've been talking about procedure all day, right? That's what we've been talking about when we're going through our advanced canonical overview. We're on part 4 now on YouTube. That's freely out there with great details. So we go into Article 3, Section 2, which defines the judicial powers of the United States, of course. Article 1, Section 8 grants Congress authority to legislate jurisdictional reach. The 10th Amendment reserves the powers to the states. And what is that? What is the last 3 words of the 10th Amendment? Can someone please tell me?
To the people respectively.
Nope. What's the last 3 words?
Constitutional limitations.
Thank you. Within constitutional limitations. All that police powers, jargon, and bullshit. The state's got police powers. Yeah, within constitutional limitations, my guy. What? So, am I too loud or am I good? Do I need to lower myself, or is the mic?
I love your hype.
Is the mic too loud?
Loving the energy, bro. Keep it going.
Okay. So the Supremacy Clause establishes federal law as supreme. Okay? The Supremacy Clause establishes the federal law as supreme. That's always your foundation, my guys. So the only thing I can go through all of this, which let's do it. Let's just keep going. I'll get to the other point later. But preempting inconsistent state laws. Jurisdiction is broadly categorized in different types, like we were speaking of, each with distinct legal implications and requirements. So here, let's go through the types of jurisdiction. Subject matter jurisdiction. This refers to a court's power to hear specific types of cases. Subject matter jurisdiction is fundamental and cannot be waived. The exclusive federal jurisdiction. Federal courts have exclusive jurisdiction over constitutional cases. Okay? So I don't care what kind of statutory criminal aspect that you are in. It all comes down to constitutional aspects. okay? Because there's always going to be constitutional rights being violated. So if it's in a criminal aspect, the injunction also does come into that. Why? Because there's constitutional violations, and that's how it ties back to the irreparable harm. That's how we're able to get all of this in relation to the injunctions.
Yeah, be careful. Don't be grabbing it. Okay, go ahead and grab that and put it in there.
Okay. So when we're speaking of that injunctions only work in civil aspects, or that's not true. Okay, so what we need to do is understand that the civil or injunctive relief halts criminal proceedings when you pull in irreparable harm. Let's look at what irreparable harm is. Okay, I've gone very thoroughly and deeply in this on a YouTube video, which you can find. It's free for everybody. It's called Irreparable Harm, and it speaks on injunctions. Okay, injunctions are not just for civil. So let's look at irreparable harm. Get to what do I want to get to? This one. Let's get to legal law in Cornell. Okay, let's go to Cornell. When we're speaking of the irreparable harm, is a legal term that refers to harm or injury to us. We're the highest. Okay, all these little cities are corporations. Therefore, it's civil. Okay. Irreparable harm is a legal term that refers to harm or injury that cannot be adequately compensated or remedied by any monetary award or damages that may be awarded later. Irreparable harm is a necessary requirement for a court to grant a preliminary injunction and or temporary restraining order. Okay, the movement or party, us, seeking the injunction usually has to prove that they will continue to suffer irreparable harm if the injunction is not granted. That means going to proceedings. That means having to deal with the courts on the lower level because of the constitutional violations. Okay, now deprivation of constitutional rights. Well, if you are in a criminal court and you have no body of harm or verified complainant, is this not a deprivation of your constitutional rights and beyond? Yes. Therefore, it is applicable to have an injunction. Okay, wanted to make that clear. So then we come back out and we go into the aspect of equitable authority to prevent constitutional violations, although commonly applied in civil disputes. Injunctions can and will be on our side invoked to restrain a criminal proceeding that lacks jurisdictional or constitutional legitimacy. Courts of equity hold the power to prevent the enforcement of illegal or void enactments that inflict irreparable harm on an accused intangible rights. Let's get into that case law that supports it, right? Footnote 3. So we're going to search this one, okay? Permitting relief where the continued enforcement shield fundamental freedoms. But let's look it up anyways. I just want to make it clear for y'all that I don't be speaking out the side. So the Supreme Court decided that the court may enjoin enforcement of a statute that has so overbroad in its prohibition of unprotected speech that it substantially prohibits protected speech. Well, guess what? We got a lot of y'all out there knowing that you're getting violated on your freedom of movement. Am I correct or not?
Amen.
Okay, thank you. It matches. Okay.
I say it with your chest, brother.
Okay, so exclusive federal jurisdiction, federal courts again. Where was we at? No, we moved over. Did we move over to here? Yeah, we're over here now. Excuse me. Where a defendant demonstrates that the state's accusations, city, county, whatever the case may be, lacks any verified complaining witness or real harm, the threatened criminal prosecution stands as an unlawful interference with the right to due process. Clearly, if it's a criminal one, we bringing it over, demonstrating irreparable harm. A key rationale for equitable intervention lies in irreparable harm. The intangible injuries, invasion of personal liberty, reputational damage, financial strain cannot be undone by a simple post-trial acquittal. Thus, an injunction is warranted to stop the criminal proceedings before they escalate into deeper deprivation of rights. If you continue to move forward in the proceedings, you are thereby violating me and causing irreparable harm. I don't want to have to deal with this. You're violating my rights. The legal foundation for injunctions as a no-victim context. Constitutional protection of liberty. The Due Process Clause of the 14th Amendment shields individuals from being subjected to spurious criminal charges absent a factual basis or legitimate complaining party. If a criminal matter is purely contrived with no real corpus delicti, an injunctive measure to halt the proceedings enforces the principle that tangible freedoms cannot be trifled with by unsupported allegations. Statutory and common law maxims. American jurisprudence repeatedly affirms that, quote, a criminal prosecution must be grounded in actual harm or wrongful act, unquote. If none exist, the charge is facially void. Courts of equity can enjoin such an action to prevent fruitless proceedings, saving time, resources for the state, right? And an individual's constitutionally protected interest. Again, this is provided to y'all. It's in the link. The link is in the description. I'll give it to you one more time. Or not this one. Let me give y'all this one. You ain't got this one yet either, and you can go over the rest of this one on your own. Listen, I'm wanting to be a benefit to you guys to have y'all understand, just what's really going on here. And that's just a little sneak peek. I can get into a little bit more. I want to ask some questions, though, just based on that aspect before getting into another thing that me and Luis developed this week. What do y'all got?
My only question is applicability. Sort of a list of how best would it be applicable. My camera, sorry. Like, is it applicable right when, from everywhere from when the cop first stops you all the way up to where you're, trying to not go to trial or what have you? Where exactly do we apply that? Like how and when we can even threaten it. We can even show that there is it. That's why I'm wondering the best insert.
Well, why would you threaten anything? Just do it.
Well, when talking to DA,
Papa, I see. Hold on, Papa, I see your hand up, but I'm gonna lower your hand. You can come up at any time and speak.
Well, he can go ahead now.
Nike, just do it. Just do it. But what it is we're gonna do is take action. So we have to take an action, and so whatever we say in this their action and interaction, we got to take a separate action. Separate action.
So is that is the first step is discovery, right? I tried to look for templates on discovery questions to send in. I don't know if there's a link that you guys have.
What do you mean when you say the first step is discovery? Like what?
Okay, so you get it. So you get it. So you get a traffic ticket, right? Okay. And so you dealt with it. You invoke all your rights. They still give you a ticket. You go on your way. You got to send in. You need to address that, right?
It depends. Do you have a contract with the state or not?
No, you need to address the ticket, not the interaction between the cop. I'd say you address the ticket.
Okay, so how do you address the ticket?
Well, you go you go in and find it. You go and first you address it. You look at it, and you determine if it's sufficient or not, and then you go you go to the judge, and he reads you the ticket and looks at it. And then the way I would do it is I'd say, hey, I want you to look at the ticket and tell me if it's sufficient to bring me into your court for you to hold me to answer. Now he's got to make a decision, and that can be yes or no, and then you can take issue with his answer.
But don't we need to keep everything in mind, that whether it's criminal or civil?
Well, tickets in California are all criminal.
They're criminal under administrative court, though.
Well, they're quasi, but they're quasi-criminal. Quasi is a jurisdiction that was made up in the 40s based upon the doctrine of exhaustion of administrative remedies. And that means that's really where you want to solve the problem. But it's an administrative court. So now you're not in a civil or criminal court. So you choose. And I know it's criminal here, so I know I'm in a criminal court, but I also know I'm in an administrative court. So, and the criminal administrative court is focused only on them getting a decision out of you. And why would you? What is it that you're disagreeing on?
Well, wasn't
there's no extra party?
Well, okay. The decision you're disagreeing on is that the invitation is insufficient to come in and talk about this situation, whatever it is, in this court. This judge doesn't have the jurisdiction to hear it.
Zeke, could you go over what the elements of sufficiency are?
Well, not here.
Okay.
I have a question.
Cam's giving us the idea. Cam's running it down. We got to learn all these things, and then it's a mumbo jumbo at first, and then we have to part it out and say what goes where, what goes where, what goes where. But first we got to go what is what is what is what, and then what goes where, what and how.
Well, when I chimed in, actually thanks for kind of began answering a portion of my question. Right now, in real time, I've been wrestling with the courts for about 4 months over 2 tickets that I have not pleaded on, and due to a failure for the prosecution to state the claim. I heard you talk about the adversary. Due to that, making a long story short, the court sent me yesterday a motion to show cause. Can you explain to me why would they do that, and what would you advise the next course of action that I take? Now, before you answer that, I'm assuming that was their plea for me to communicate in a way for me to get the dismissal or the remedy that I've been wrestling for. So am I in the right ballpark of thinking that? And again, how would you approach the motion to show cause?
Zeke, I'm gonna let you answer that one.
I was going to let you answer that, Cam.
No, you got it.
Okay, well, first of all, I think just generally, I think that is the right deal, because I don't know what they're asking you to show cause. I don't see their paper.
Well, it's a blank motion to show cause, for one. No wet ink on it. And I did file 4 months ago, before the proceedings began, a affidavit of truth that they have not responded to.
Okay, now when you say they sent you an order to show cause, so they sent you a blank form?
Yes.
Okay, so yeah, so you need to show the order to show. You need to they're giving you the hint, I think, because your order to show cause is you want them to show cause and I don't know if you have to break it down. So you have to think about it for each situation of show cause as to how the court has jurisdiction.
Right.
That's what we want them to do.
Doesn't the affidavit of truth speak to those matters? And they haven't responded.
So wait a minute. So yes, but you gave an affidavit of truth, okay? But that doesn't mean anything to anybody. So they're saying to you, look, you make us address the causes of action, because in your affidavit of truth, what you said, okay, you said it, but you want them to show cause as to whether what is true about it or what's not true about it.
Right.
But not in those words. See, you want them to show cause that they can proceed.
Right.
What do they have to show that they can proceed beyond in this court? Okay, so that's the general. I don't know how I'd word it yet, but yeah, show cause. That's what everything is, show cause.
So should I attach my affidavit of truth to the motion?
No, you want them to show cause that they have authority to proceed in this case. Because just because you said it, you might be wrong. But you want to get the right answer. What cause do they have? Now you can, lay it out the way you see it, but they still got to show cause. You can, tell them those things like you said, okay, and that the show cause is like you're asking for an injunction, as he's putting up there, because you're making them show cause why show cause why you should not dismiss the case. There it is.
Right.
That's what you want to ask them. It doesn't matter what you said.
So something else I just wanted to add.
I'm still kind of left with a question mark. What should be my next course of action in their move on the chessboard by sending me the motion to show cause? What should I do next?
You should send them a motion to show cause. Why? Ask them why, show cause why you should proceed in this case, and then you attach the ticket, the complaint, as an exhibit to so that they can look at it, and they'll go, oh, why should we proceed? And then they'll look at their complaint, and then what's the reason to proceed? And they have to show you on the complaint their authority to proceed.
Right. Shouldn't that be where my affidavit of truth is acknowledged, and shouldn't they be held to task to answer point by point as
No. They need to show cause why they're proceeding on the complaint. Doesn't matter what you said.
Wouldn't they show cause? Like, okay, so let's say you have your driver's license and you provided that for some reason, right? So they would show cause because you provided your driver's license, right?
Well, then they would have to prove you're operating commerce. Can they provide
wait a minute. No, that's the theory that you have, because they're not going to do that.
Well, check it out. What I wanted to get into real quick, y'all, is the injunctive relief to halt ultra-vires and unconstitutional prosecutions real quick before then jumping over into a little bit more. So the extraordinary nature of injunctions in criminal matters, right? Extraordinary nature of injunctions in criminal matters. Why is it extraordinary? Because again, it's causing irreparable harm. Traditionally, courts hesitate to enjoin criminal prosecutions. However, when a proceeding patently lacks jurisdictional footing or contravenes fundamental constitutional mandates, fails to demonstrate a verified complainant, equity may intervene. Absent such relief, an accused is forced through the empty, injurious criminal process with no real recourse post-conviction. Immediate irreparable harm. A proceeding hinging on non-existent victims or tangible harms can inflict irreparable injuries upon the defendant's liberty, reputation, and finances. We've already gone through this, but I'm just showing you one more thing. Now, what I was wanting to also show y'all is, let me see, the aspect of the motion to strike that's so beautiful, right? You know what I'm talking about? So let me see what's going on here. So we got objection for lack of ratification of commencement and no claim. Now, under both federal rules and state rules of civil procedure, I know people be like, civil procedure, but you're in a criminal matter, Cameron. Again, these are corporations. I don't know how much more clear I need to make that. They are all corporations. If there's no harm, there's no crime. That's how this works.
Hey, can I add something? The International Organization Immunities Act of 1943, or 49 Statute 3097, Treaty Series 881, put all the courts and all the states under the United Nations. That's a violation of our 11th Amendment. Unless they got a FAR registration, right?
Okay, watch out now. Now,
So-
in the...
So the trial rules says, and Rule 1 or Rule 2, the scope states that all actions are civil actions.
Thank you. I appreciate that, and you are correct. Now, notice this is what I wanted to get into. Luis literally spent like 2 days, man, where he was just going and scouring case law. Okay, actually, I want to do justice on this, and I actually just want to share the document that he shared with me. Hold on one second. Where's this at? 1 second, I'll find it. We've been talking a lot, but hold on.
Unless they have a FAR registration, would that mean they don't have no standing?
Come back down, open. Okay, boom.
This is in the Discord, right?
Yeah. Where am I sharing? Oh my gosh, I can't find what I'm sharing. Oh, it's this one. Okay, share. All right, can y'all see this?
Yeah.
Okay, cool. Continuous scroll and then zoom. Okay. So he brought forth this notice to dismiss for lack of personal jurisdiction. He developed this himself and filed it. Comes now Luis Armando Ochoa Ibarra, herein after the called defendant, right? Brings this up. Challenge jurisdiction. When it clearly appears that the court, and this is why Luis doing this apparently. He said, my boy filed this and he goes, bro, they have to listen to case law. If they don't want to listen to my opinion, I'll just give them a whole bunch of case law. That's what he's doing. Excuse me. Now, when it clearly appears that the court lacks jurisdiction, the court has no authority to reach the merits. In such a situation, the action should be dismissed for, again, want of jurisdiction. Mello versus the United States. Once jurisdiction is challenged, it must be proven. Where there is an absence of jurisdiction, all administrative and judicial proceedings are a nullity and confer no right, offer no protection, and afford no justification, and may be rejected upon direct attack. Thompson versus Tolmie. Jurisdiction can be challenged at any time, even on a final determination. Basso versus Utah Power and Light Company. The state is bound by the Supremacy Clause of the United States of America Constitution and has failed to the procedure of the Constitution. Minimum. Below are points of authorities. Constitutional minimum. American Family Association and Michigan State University Board of Trustees. United States Supreme Court Luan test, Luan held. Over the years, our cases have established that the irreducible constitutional minimum of standing contains three elements. That magical number. First, the plaintiff must have suffered an injury in fact. Not an injury in theory, an injury in fact. It must be solid. It must be material. Hello?
Cam?
Yes, sir.
That translates to the right to relief.
Yes, sir.
So you got three, so you're going to run them down here. That's the right to relief.
Yes, sir. An invasion of legally protected interest, which is a concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. Because like in my boy Luis's situation, what they do, and they hypothetically saying, oh, we know your intent. You was on the roads because you were going on toll roads and didn't want to pay. What? Why are you making out of here putting all these hypothetical situations on me like they can even...
Now that's going to be defined on the complaint as the claim for relief.
Second, there must be a causal connection between the injury and the conduct complained of.
That's the claim.
Oh, you know what? What I'll do too is, I think I could throw this over in the chat. Hold on, y'all. What do I do? Chat. Oh, chat. Okay, and then if I drag this over, well, come on, let me drag it, guys. Oh, it'll work. Okay, so this is the same document. Okay, cool. Where are we at? Not conjectural or hypothetical. Second, there must be a causal connection between the injury and the conduct complained of. What? There must be a causal connection between the injury and conduct complained of.
It's the right to relief.
The injury...
That's causal, not casual. That's causal, as in there's a cause.
Oh, excuse me. Sorry, guys. Yeah. Thank you for calling me out on that. Thanks for the help. Okay, so where are we at? Complained of. The injury has to be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party, not before the court. Thank you. Third, it must be likely as opposed to merely speculative that the injury will be redressed for a favorable decision. Now, this is applicable to almost everybody's situation out there if you haven't really caused any true harm, right or wrong. Am I right or wrong in this? Yeah.
Right, because there's no harm, there's no injury.
Exactly. Quote, the party invoking jurisdiction bears the burden of establishing these elements. The court observed, perhaps the most critical element of the judicial power has been its requirement of a genuine case or controversy between the parties, one in which there is a real, not a hypothetical, made up in your mind type situation and oh, we believe that this is what he was doing. Prove it, my guy. Dispute, and one in which the plaintiff has suffered a particularized or personal injury. Well, there is none. How you gonna say there's an injury when I'm sitting here minding my own business?
But there's also no dispute.
Ooh, go into that a little bit more, Papa.
Well, in our case, we didn't hit somebody or cause an injury. They said we didn't have a driver's license, and we agreed. No dispute.
Facts. I like that. You're right. When that's when they asked me, do you have a driver's license? I don't, good sir. You thought I had a contract with you? Bet you was hoping for that, wasn't you? No, sir, not me. But even in and such, if we were, hey, man, it's all about the intent and purposes in which you are currently on the roads at that particular point and moment in time. So
That's right. And don't presume that a license is a contract.
correct. Well, what do you mean? Whoa. What do you mean? Don't presume that the license is a contract? What do you mean?
That's right.
What do you mean? By the officer or us now?
By us.
Well, how could it not be anything other than a contract?
Well,
It's well established.
Right.
Look at it. It is an
you go to
agreement
the
between
state
two parties, and did both parties sign the agreement? I only see one signature on there. I don't see two signatures. There's no agreement.
That wasn't a
Agreement
meaning
to
of
what?
money.
What's the
Supreme
agreement?
Court has said a license is not
contract law. But did
I see that point. That's a really good point. That's a really good point.
Now we're gonna blow your mind.
Yeah, that was a really good point.
Just remember, when you go to the driver's license bureau, you go in and you're asking for a license.
Right.
So you're requesting, you're giving away your right
Yes.
for a privilege. You go through, you do
I object.
you do their study, you go through their book, the rules of the road, you take a test, you pass that test, then you go, you get your eye test, you get your picture taken, it's put on a license with your signature.
Sounds like an instrument.
It sounds like it doesn't mean anything.
You know what it sounds like to me? It sounds like a waiver of your rights
No,
in a
that's not
legal
true.
aspect and form.
I disagree.
Bingo.
I disagree.
I can explain that.
No, it's not a
Okay,
waiver
the
of your
first
rights. It's just your license to use the road in commerce if you so choose.
You're
That's
giving
it.
up
Let me
your
explain,
right.
please.
I
Let me
disagree.
explain.
You're
Okay.
giving up your right by requesting
No.
and asking for a license.
I
Excuse
disagree.
me. That is not true. You cannot give up a right. Okay. First
right.
of all, you retain your right. What you're doing is you're asking for a privilege.
I agree and disagree.
That's just what I said. Just what I said. You're giving up your right for a
No,
privilege.
that is not the
Yeah,
same.
That's right.
You are asking for a privilege, a right. Everybody has the right, but not everybody has a privilege.
Yes.
You are paying for a privilege to use the roads for proper gain. We
I
all have
agree,
a
but
right to use the
disagree.
public roads. Well, it's in case law. You just have to find it.
Well, I agree. Yeah. Well, you got to remember how we're looking at everything.
Now,
I
one
say
last.
this.
Okay, go ahead.
I have a right to go to anybody's house and go ask them if they'll put a picture on something, if they'll do anything, and if they'll give me a piece of paper. And then now I got a piece of paper, and that piece of paper doesn't mean anything. And I paid them to get it, and now I got a piece of paper that doesn't mean anything. But everyone can make presumptions about it if you read it, but it don't mean anything. And then when you look at the license, it just has your name and address and how tall you are and what a couple other. That's about it. There's no contract there.
Right, correct. Asking for a privilege is not a contract.
And I wrote up. I got my own license. I put my picture on it, and it has my ID on it, but it didn't have my date of birth on there. And one time when I went to the bar, and my buddy went through, and the guy says, "Let me see your license," and I show him this license I made up. But first he stopped me because he wanted to see my ID, and then he goes, and it didn't have my date of birth on there, but he goes, "Oh, you didn't have enough gray in your beard." So it's just it's just the ID, and it doesn't mean anything. And you can make up your own ID, and you don't have to put the day. You don't have, because it's ID.
It means one thing. It does mean one thing other than just ID, guys. It does mean instrument because that's how they get to the money.
No, it doesn't mean instrument. No, it doesn't mean that. You're reading into it.
Let me finish.
There are many forms of contracts, and there are implied contracts. There are written contracts. Everything's a contract.
That's right.
We just have to define what kind of contract is it.
Right.
Well, yeah. First, you got to know the types of contracts. Okay.
Hey.
And then, because if you do something, then you're agreeing to that contract. You're just agreeing. It can be implied, written, or verbal. Those are the three kinds of contracts. And a lot of them are implied. So as long as you go along, it's implied that you agree.
Hey,
but if you don't go along, then the implication becomes appears, and then it can become relevant if you make it relevant. So we're all in implied contracts by just talking here. But then as soon as someone interrupts someone else and then interrupts that, well, in this situation, our contract is, yeah, we're allowed to interrupt. But in a formal situation, the implied contract is that you don't interrupt. Okay, so that's just how you look at the implied contract. And if it's written, then you violated the oral or written contract, and then someone can take action upon that violation, and whatever that action is.
Hey, Erica and Hayden, can y'all please unmute and come up? I'd like to bring y'all forth for the last part of today's Operation Wisedome for YouTube.
Okay.
Where you at, bro? We can barely hear you. You gotta turn that thing up.
Can you hear me now?
You sound like you're in a tunnel, bro.
Oh, it's because I got my AirPods on. Hold on real quick.
Oh, that sounds better. What'd you do?
Oh, nothing. There you go.
So just quickly, Hayden this week, well, let me give a quick breakdown. So Hayden caught a DUI. It's covered on the YouTube, and let me provide that for y'all just so you can kind of see what happened. Homeboy had a DUI, right? And it really, I don't know. We still haven't seen dash cam video. We're waiting for that, but we haven't seen it yet. So we need to get did I do that live or not? Let me see. Was that a live session? It was a live session. Okay. So share, copy, and then paste, send. So that's his stop right there on YouTube. And what ends up happening is he gets a lawyer. They pay the lawyer like $5K, right? And all the lawyer does, he claims that he works 56 hours, bro. But all he literally did, what did he do, Hayden?
He filed my formal review hearing motion to dismiss. I don't know if it was a dismissal or not, but that was with the DMV. It wasn't even with the court.
His ass didn't even file anything with the court, y'all. So then Hayden finds us, and he's skeptical as fuck, yo. He's skeptical. He's like, what? Who's this guy? And he's not taking it really like super serious. And then he comes into Operation Wisedome, and he's like, okay, this is serious. He sees the Discord. He's like, okay, this is serious, and we get to work. We start developing documents. We get him in to start utilizing ChatGPT, asking the right questions. This dude, when I tell you, went to court, got rid of his attorney, and went to court this week, like he'd done been to court 4 or 5 times before, is insane to me, and it's so empowering. And I just want him to tell his story real quick. Go ahead, Hayden.
Well, I'll keep it short. This happened back in May, so a lot of time has passed with, almost no communication with my ex-attorney. So I met with him back in October, and then I met with him again, I guess, in December. And the second time that I met with him, he was just talking about settlement. And I was like, but I didn't do anything wrong, Like I was like, this is really sickening. And then it couldn't have been but like a week after that, where of all the YouTube videos of all the various personalities, Cam came up, and it wasn't even him, presenting himself in this current fashion. It was just him like showing his encounters with stops, and I didn't even know his name at this point. And I think it was Brian over at Here's the Deal who said, "You got to check out Cam." And I was like, "Well, who's this camera guy?" Well, it was a dude dealing
Stop
with the
talking
hood
about
river cop.
stop talking about me and start talking about how great this week went for you in your court case, please. Come on, give it to the people.
Oh, well, I mean, it was, man, all right. So my heart was beating out of my chest all day, sitting outside the courtroom like it had to have been 100 degrees. I was sweating my ass off.
Oh, was you? It's toasty.
What's that?
You went in there with wet armpits?
I was actually, I mean, my face was a lot sweatier than my armpits, but yeah, I was
okay.
a little sweaty. It
Okay.
was a little cooler in the courtroom, but for some reason, you know, when I sat down, you know, on the bench, you know, on you know the near side of the fence or whatever that thing's called, I did settle in a little bit as far as nerves went. You know, just having the experience of being in there and seeing things going on with other people, even though they weren't taking the same path I was, just kind of put me at ease a little bit. And then, you know, I really just kind of let the judge lead. And I don't know if she's a good judge or not, but she seemed to make it easy for me to.
Now wait a second. You said you don't seem like she was a good judge. There's
No,
something
no. I
okay.
don't know whether she is or not.
Okay, now let me ask you something then before you get too far. Did you hear anything about reckless in there?
When so that was she asked the state attorney what
She was hinting. That's what was going on. What there was happening right there was a hint to place on the record to just go ahead and lower the DUI now that you're representing yourself to a reckless. See what they're doing now? They're hinting at going ahead and dropping instead of taking this further because of the constitutional violations that are currently being seen.
That was already an established settlement offer.
Okay. Oh, now we're getting somewhere. So now the case is getting so weak that we know we can move for a complete dismissal all the way. If they're trying to settle with you, are you going to take it?
Well, like I said, so of course not. You know, I mean, I don't know what's gonna happen, right? Like, but it's like you said, you know, regardless of what happens, really, there's two things for me, right? Like the biggest reason I canned my attorney is because no one knows the facts of the case better than I do.
Mm-hmm.
And then, you know, we spoke a few weeks back and you said, look, you're not going to jail. And even if you get a conviction, we're just setting it up for an appeal.
Yeah, but you're not going to get a conviction.
Makes most sense, right? Like, because like the lower courts obviously suck. And so to set everything up to go to a higher court who has, I guess, more authority is like, that's where, you know, a lot of my comfort comes into play.
Yeah, there's no doubt. So, like I said, though, I'm just so proud of you, bro. Like, going in this week and just standing there like a boss. Like Indigo just said, she's like, I think you did amazing, because you did. And I'm just proud of you for going in this week with court, getting rid of your attorney and saying, let's handle this myself. And I'm going to be like, don't submit and don't take the reckless, because you got a civil suit, bro.
Yeah.
You literally have a good civil suit, bro. And so I just want to, there you go, girl. Okay. So I just want to say I'm proud of you. And Erica finally came on. So come on, Erica, get on up here. You're next. And go ahead and unmute yourself. So I've been working with Erica this week pretty heavily, and including a bunch of other people, but Erica as well pretty heavily. And she had court this week too. Someone's got their hand raised. I'm gonna have to lower your hand for right now, but you can come on here in a little bit, but just hold on. I'm gonna lower your hand because I gotta move faces in front of me to see properly. There's a bunch of people on camera. But go ahead and start off just how this week went from you, I guess, from what we went through last Saturday to this Saturday, and how you're feeling about the situation, and we'll show something else too. Go ahead.
Hi. Thank you for everything, by the way. I filed my dismissal on Friday to dismiss my judge. And on Saturday, he sent me something saying on Monday he was going to file a dismissal himself, but I had to wait and see. So I basically just told him that I didn't want him to speak for me. And he was like, well, it's up to the judge. And so I went and did exactly what Zeke had helped me with, and pointing out that when reading it, it's not clear. And so the complaint was insufficient, and I objected to him entering a plea. And then it was basically, I was in the same situation as Hayden was, but I didn't want to sign the piece of paper that he did. So I got a continuance for 2 weeks. So now I have to find out how this affects my hearing date on the 24th, because my rearrangement actually is supposed to be the beginning part of starting over, but I already have.
Uh-oh. Erica, you froze. Damn it. We lost her. Erica, come back.
I didn't go anywhere.
Okay, you're freezing though.
I didn't even move.
It's just, you didn't move, but you froze. Okay, keep going, sorry.
Can you hear me better?
Yeah, you're good now.
Okay. So basically I need to work on filing my dismissal. Karen and I were talking about.
Wait.
Well, actually, no, the remand. We're going to remand it.
Wait. Don't do it. Don't, not yet. Okay, hold on, we'll get there. So what I want to do is I want to show everybody what we went through. Is that okay?
Mm-hmm.
Okay, let's do it like that. Okay, so where are we at? We're going to share this screen. And like this. And let me... Are y'all hearing music or no? Tell me.
Yeah.
Uh-oh.
Yeah.
Okay. Let me pause it then. Okay. So what we did is, if y'all don't know, this is the Discord here. Oh, wait. Am I sharing it? Oh, yeah. Y'all can see it. Okay. So this is the Discord here. If you're new and you haven't seen what's going on, over here we have voice channels, and we come in and chit-chat in the Wisedome chat, where we actually... I'll do work with somebody else while other people are watching and stuff. And then we have a general one down here too. And then we have text channels. So we have quite a few text channels where you can come in here and text it and just chit chat about anything and everything. And then the casework. So as you'll notice over here, we got, I think, over 40 cases that we're working on right now. Right. So pretty amazing stuff that we've been able to create, and the community in here is just outstanding. I just want to commend y'all for all that first off. But this week, what we went through is Erica just had them go ahead and move forward with the grand jury hearing. And when we were kind of speaking about this, I think 2 days ago, what we ended up finding out, of course, is there's some real bad inconsistencies with the grand jury hearing in and of itself. Like, it's just really bad. There's all kind of false allegations, misstatements, someone speaking on someone else's behalf. It's just horrible. And so when we were looking into certain aspects, when I was working with another one of the members over in New York, Ocasio Wilson, what we were looking in his paperwork is that it does give them the right to actually attend the grand jury hearing. And I was like, what? You actually get that? And when I was looking into that for Erica, she doesn't. They take it away from her. But something that we did find out that was pretty amazing was that under the Arizona rules of criminal procedure, defendants do not have the right, and then the prosecutors do not require, limited opportunities, even though the defendant does not get to attend. Arizona does allow certain procedures to challenge an indictment if the defendant can show that the process was somehow legally flawed, key exculpatory evidence, or improperly withheld from the grand jury, which we do have that. A defendant may move to remand the case to the grand jury if it appears the grand jury did not receive a full and fair presentation of the evidence. Okay? Preliminary hearing versus grand jury. Okay? In Arizona, the prosecution can choose either a grand jury proceeding or a preliminary hearing to establish probable cause. Okay? This is how they're going about probable cause, but again, it's kind of a violation of our due process rights, to be honest with you, especially with all the hearsay that's going on. In a preliminary hearing, the defendant does have the right to appear, cross-examine witnesses, and be represented by counsel. By opting for a grand jury, the prosecution circumvents those rights for the defendant. Legally permissible. I don't see how, but it is legally permissible. Okay? let me get this right. Legally permissible so long as the rules governing the grand jury are followed. Well, clearly we have rules that were violated. We have the transcript. We're going to pull that bad boy out, and we're going to do what's called a remand. Now, if indicted by a grand jury, the defendant's recourse primarily lies in post-indictment challenges, motion to dismiss or remand, arguing an unfair or legally insufficient process, rather than asserting a right to observe or participate in it. So,
just on that point there, what came to me is, okay, we know she can't appear there, but we know that they need to have a be fully informed of everything, which they weren't. So I'm thinking that maybe she can write her affidavit of what happened and then submit it without her being there.
well, I think the way that we're going is a remand. We're going to send it back.
Talking about on the remand.
Okay, so the detailed discussion of the remand procedure in Arizona. Once an indictment has been returned by a grand jury, a defendant appearing in propria persona representing oneself without counsel I gotta make this bigger for y'all. I'm not gonna read this shit that small. Excuse me. Give me 1 second here, y'all.
Thank you.
You're welcome. Excuse me. Docs, and then docs, blank document, paste. And I hate Arial font, so let me change this real quick. And we'll take it up to 13 and get to reading, you dig? All right, let's go. Well, I can zoom in. I can fit it to the page. Yeah, I can do it like this. Is that better, y'all?
Perfect.
Okay,
There
good.
you go.
Good.
I like it.
In Arizona, once an indictment has been returned by a grand jury, the defendant appearing in propria persona representing oneself without may challenge the validity of that indictment by filing a motion to remand the matter to the same, or more commonly, a different grand jury. Okay? We're getting fair over here. We don't read the transcript. We know it's full of it's full of errors, okay? This is typically, and we're going to prove it. This is typically done under Rule 12.9 of the Arizona Rules of Criminal Procedure, which allows for a motion for a new finding of probable cause. So that's what we're going to next. They've come forth. They've given us we've asked for more time to review everything. He pushed off the arraignment to say, hey, okay, we're going to push it off. We'll see you on the next one. We've reviewed everything. We've come forth, and now we're going to come forth with a motion for a new finding of probable cause, moving I'm telling you, man, it's going to be great. Y'all going to see it. It's going to be amazing. So below is an advanced legal explanation of this process and its underpinnings. So not only are we developing it, but here we go on understanding everything that we need to do in relation to it, right? So the jurisdiction and procedural grounds for remand, rule-based authority, pursuant to Rule 12.9 of the Arizona Rules of Criminal Procedure, a defendant may seek remand when there is an allegation of irregularity in the grand jury proceeding sufficient to cast doubt upon the integrity of the indictment. Examples of such irregularities include, but are not limited to, the prosecution's failure to present clearly exculpatory evidence known to it, presentation of misleading or false testimony to the grand jurors. Erica, was there false or misleading testimony?
Yes. A lot.
A lot. Procedural irregularities that substantially infringe upon the grand jury's independent decision-making, time constraints. The motion must typically be filed within 25 or time constraints, right? So now we're going into the time constraints on how quickly this motion must be filed after a grand jury indictment. The motion must typically be filed within 25 days after the defendant's arraignment or within such a time frame as the rules or court might prescribe. Failure to adhere to this, of course, may preclude the defendant from asserting a remand argument at a later juncture. The burden of proof. Now, the movant, us, the defendant, proceeding pro per, bears the burden of demonstrating. And I promise you we will be able to demonstrate. Because all we literally have to do is pull from Homeboy's own transcript, okay?
Yeah.
Both of their incident reports to show that what this sergeant said is a lie, because on the stand she acted as though she could adequately answer the questions that was being proposed to her, such as, was Erica punching the officer? I'm sorry, lady, but you wasn't even there to verify that. So your statements of yes are not true, and therefore misstatements. They're hearsay, okay?
And
That's
all
how
the
deep
evidence-
this shit goes.
All the evidence is provided by them, not by your declaration or your affidavit. It's all provided by them.
Now, where was we at? Did I stop? I always do this, bears the burden of demonstrating a colorable claim that the challenged irregularity significantly impaired the grand jury's ability to determine probable cause. Well, it does, thereby undermining the resultant indictment. 2. Substantive basis. Exculpatory evidence and prosecutorial duties. Now, a recurring ground for seeking remand is the prosecution's failure to present exculpatory evidence to the grand jury. Okay, can somebody explain to me a little bit further on what exculpatory evidence is?
Evidence that can prove your innocence.
Okay, now, exculpatory grand jury. Arizona law imposes a certain obligation upon prosecutors to ensure that the grand jury receives evidence that is not merely inculpatory, but also substantially exculpatory. Did they do so, Erica?
No.
How did they not do so?
What do you mean?
Well, how did they not also provide evidence that was also beneficial to you?
They excluded her.
Yeah, I'm trying to figure out what. No, I know.
Well,
just
there's a lot of evidence that they didn't even give me.
Mm-hmm. But in the grand jury, but I'm speaking in the grand jury proceeding itself.
They didn't
I'll tell
give
you.
the original cop statement.
Well, they didn't even state that they made it very vague that she didn't have it in her hand, right? They didn't let them know that they never saw it in her hand or anything like that. They left it to assume that she grabbed it and hit him with it, right? They didn't give the evidence forward that they had no evidence. There was never a statement that she grabbed it and hit it. We pulled her out of the car and we turned around and there's a crowbar. Well, that doesn't mean she hit you with it, my guy, right? Then we also go into the aspect of them saying that the cop suffered a concussion. Well, that's a total lie. There's no data whatsoever that says he got a concussion. In fact, what does it say, Erica?
The medical report from a different place that the first judge told me that they took him says that there's nothing wrong with him. There's
at all.
Everything they checked out says normal, no acute tissue, nothing was broken, he wasn't even bleeding.
Yep.
His hat never even got knocked off, for fuck's sake.
Nope. So next is the nature of the exculpatory evidence. Exculpatory evidence comprises any evidence that might lead a reasonable grand jury to question whether probable cause exists. Even if such evidence is not conclusively exonerative, it may be sufficient if it reasonably tends to negate the defendant's guilt. The materiality threshold. The defendant must show that the withheld or mischaracterized evidence was material, meaning that there is a reasonable probability the grand jury would have declined to indict or would have returned a different outcome, which they would have had it been presented or accurately conveyed, which it was not. That's why they've been stringing this out with her for over a year to try to get her outside of the state tort claims and stuff like that, because she's so worked up and dealing with all this irreparable harm. So the consequences of withholding. If the court is persuaded that the omission or distortion of the exculpatory evidence comprises the fairness of the proceeding, it may order the indictment quashed. Bing, bang, baby, let's go get them. Remanding the matter to the grand jury for reconsideration. And when they reconsider this bad boy, it's going to be found null and void. I'm calling it into existence now. Because we are going to put in enough work to make it come to pass. It is our responsibility. In some instances, the court may dismiss the charges outright. We've got that possibility.
Yep.
Through dismissal without prejudice, allowing the state to refile is more common. But will they? No. They're not going to waste their resources anymore when they've looked so stupid in the first place. 3. The procedural mechanics for pro per litigant. When challenging the indictment in pro persona, of course, you got to consider these, which is drafting the motion to remand. Oh, we ain't got to go through this. Yeah, that's fine. We ain't got to go through that. It's good details there. But
there you go.
It's a good breakdown, y'all, of the next steps of where we're going to her next probable cause hearing. Erica, you want to share some words, dear?
I just wanted to say thank you to you and to everybody for supporting me in this, because
If I can get my ass down there, girl, when it gets crazy, I'm coming. And I'm going to try and bring Lane Myers and the whole Pro Se posse down there and Tucson Police Sucks Foundation and all that. I mean, I can't wait to get to the point where we literally can show up somewhere 30, 40 deep like Carl Miller used to do back in the day
And
and
just
show them who
influence.
runs this thing. Yes, sir.
Mm-hmm.
It's coming.
Damn.
I feel it. I know it.
God damn it, Cameron.
I've got a few people who are willing to they keep saying, do you want me to come? And I'm like, that'd be great, but then they don't come when it comes down to it. So
It gets hard sometimes, but I think I'm getting to the point where I can work and move and not have to be just here in my little closet broom office, you know. So
Create our own grand jury.
No, we got one. We don't need to do it. We go to their grand jury and we use them. She's going to do it. This is, when you see what Cam just said and saw and laid out, and you understand the facts, that's why he's so excited.
Yeah, it's over
Erica,
with.
when she's getting it, it's super exciting. You know, I've been at where Cam's at. I've been there for 40 years. When I started, I was just like that. We got it. We got to get the posse. We got to get people together. We were getting people meetings, and we had.
Well, you're back in it now, buddy. When we go over there, you're right there in Cali. You might as well come on over.
I might as well.
Okay, let's do it.
Let's do it.
Hey, one second real quick. Shameless plug. I just put in a link into there. Anybody new or anybody who hasn't gotten this yet, this is a must-have. Okay? Self-Governing Bruh is probably going to be the best book that you're ever going to have in your life. I'm not even joking, bro. Like, I'm dead serious, my guy. Okay? I wouldn't put that on anybody.
I got confirmation that my book is on its way, Cameron.
Let's go.
Me too. And I
It
got to
should be
tell
torn
you,
up and written through like your Bible.
I don't know about all that, but it's pretty good.
Well,
Not
not
even
torn
reading
up,
it.
but like damaged.
I judged it. I judged it by the cover. I haven't read it, and I may not even read it, but I judged it by the cover because there it is. Just read the cover.
Now let me ask y'all this. We're coming up on 12 quick. I do got some other time. I got other things that I've dedicated myself to. What I'll do is I want to end the YouTube and then just allow the chat to stay open for everybody to chit chat and just find some kind of help wherever that may be. Of course, you know Operation Wisedome is all about coming together, and that's what y'all always do. Normally, if you're here for the first time, sometimes I'm able to stay 6 and 7 hours like we have done several times before. Sometimes I'm not. Today is one of them. So, but I am going to leave everything open for everybody. But I do want to ask from today's Operation Wisedome meeting, if anybody wants to come up and just kind of give any words of encouragement. I mean, who wants to say anything? Please come up and share yourself before we get out of here today.
Naomi, introduce yourself.
Anybody want to say anything out there to YouTube world and just kind of show, you know, how you feel about Operation Wisedome and just anything?
Yeah, man. Hey, check it out. I'm really, really excited, Erica, to hear the successes and the next steps in y'all's case that y'all are sitting here building against these crooks, really. And I think that watching you guys is, well, you specifically going through this and having the strength and the dedication to follow through, like just to even follow through with what Cameron's putting out there for us to learn. I think it encourages me more than anything else, really. It keeps the fire lit in my heart. And I'm like, you know what? If she can handle this shit, I definitely can handle this. I'm going to go fight it. I'm going to go talk to these people and we're going to make this right. So keep it up, man.
Yeah.
Keep it up, Erica. Great attitude.
Yeah, she's doing great. And if anybody's new in here and doesn't know Erica's situation, Erica literally the cops are claiming that Erica hit the cops with a crowbar, y'all.
With a crowbar, dude.
Just so you know, if you don't know, that's what's going on. And it never happened.
She's real violent.
Fucking gangster, bro. The most gangsters ever. Like, I hit a cop in my car. I hit a cop in my car, but Erica's out there swinging and banging in that thing.
Hell yeah.
No
When
prior
they pulled her
record
out of the
either.
car, the crowbar fell out.
Well,
So
to piggyback off what Bryce said, I mean, Erica's energy today is totally different, and I'm glad that it's inspiring and it's helping me as well. It's great that this is a great. I ain't gonna say support group because we all connected, we all one, and it's just all this energy and this is good vibe. It's just a good. I'm glad for this tribe. I'm glad for everyone that's up on here.
It is a support group.
Yes, it is.
Yeah.
But
There
it's
she
just
is.
it's a great thing. It's just great. It's good
Quentin,
to see you. It's good to see you, Erica, because last week, woo!
I know.
But this week is a different energy. Just
yeah,
thank you.
she did it, bro. She got rid of that attorney. That attorney was on her back leeching.
Yeah,
It
that was a
giving her-
problem.
Yeah, it was.
She looks a lot better. You look a lot enlightened, and a big weight has been lifted off of you, Erica.
Well, we talked a lot.
It shows in your face.
Didn't we talk a lot? I had to get her up out of it. I was like, babe, you got this. So Quentin said this too, which was very weird. And I never really thought about this like this. Like, I know that I'm instilling empowerment, but I never knew that I was instilling relief and therapy for people. I never would have realized that. And when Quentin told me that too, he was like, dude, this what
It's
we've
part of the
created.
collective consciousness.
Yeah, what he said by Operation Wisedome, it's empowered me, and it's been somewhat of a therapy because of the situation that I went to and the PTSD that I currently had, that has been relinquished and taken off of me by connecting in this manner. And it's just such a blessing to know that I'm a part of this and that we've created this like this. It's just, God is great. All praise
Cameron,
go to
can
God.
I say something?
Please.
Hey, it's Mandy. How are you?
Good.
Okay. What's up? So yeah, I definitely just wanted to share that I personally, I have gone through my journey 5 years ago when my children were literally taken out of the state from Virginia and brought back here to Cali. And so that's where my journey kind of started in all this. And it brought me to Cam's community. And I will say, going through the different people, you try to see and choose who's in alignment with you. And although there are some good people out there, you got to also look at what's in alignment. And I've never, ever seen a group like this where you are looking at real time cases where people are working through their shit. And that in itself is so like just such an empowering thing to see, where you see like, he's not just talking his shit, excuse my language, he's walking it. He's not just talking it, but he's walking it. And he's just a fucking goofball, I mean, he makes it fun, and he's like, he just is such a strong person. But everybody here, like all these people in here, put their intelligence and their own experience of what they've been through. So I can just definitely attest that this group really did give me the courage. And I consider myself a pretty tough woman and mother, right? My last incident happened in August. My daughter was literally taken from me at gunpoint. They pulled guns on me like I was fucking, like a drug lord. It was wild. And when you're alone in it by yourself, you think, oh my God, did I do that? Am I wrong? You start doubting yourself, and shit is not true. So I just want to say that this community brought me back to life in a sense, where I was actually in a deep depression. I didn't even know it. And I started going to group therapy and one-on-one. But what I realized is it was Cam's group that hit something in me that made me have the courage to go back and even look at my case. Because I have to say, sometimes we can't even look at the paperwork. It hurts so bad.
Yeah.
Amen, sister.
It's paralyzing.
Yeah.
So I just wanted to give that 2 cents and say I love everybody that's part of this. And Erica,
Love you too, girl.
another thank you. The men are strong, but it's good to see strong women do it too. So I'm proud of everyone
I
here.
want to take a moment and thank Cameron for all he's been doing.
Okay, go ahead.
He's appeared in a one-legged man in an ass-kicking contest.
You don't want to get kicked in the shin by me, bro. You going down. Okay, I promise that.
Cam, it's April. I need to say something to Erica.
Okay, hold on 1 second, dear. What I'm gonna say is, everybody on YouTube, you see it. Okay, it speaks. This is truth. This is real. This ain't no Fandango guru gatekeeping. This is real. It's time. It's here. It's now. And it ain't coming with hate. It ain't coming with violence. It ain't coming with us against them. It's coming with unity, knowledge, integrity, moral, and respect. Because I am you, and we are us, and we are all a part of the great I am. Yo, Wisedome group, y'all tell everybody on YouTube. Holla.
Holla. Peace.
Join us next time.
Now when you know it, you heard me.
Hasta luego.
Whoop, whoop.
My people perish for lack of knowledge.
Hey, Cam, could I have about 30 seconds?